do an introduction and why we're here. So basically the audience is majorly corporate counsels who have a lot of questions as the Nigerian Bar Association elections is coming up. They feel they want a voice, and they feel this is just the perfect time to have a parley with you, especially in the event that you are elected the president of the NBA. Before we go into the main issue and the main crux of the matter today, I would like to just drop a few ground rules which will govern this conversation. Please let us all note that we have the Q&A box, which we can drop our questions. And please note that it's different from the chat box, where you can parley with our colleagues and so on and so forth. So I'll start, sir, with an introduction of our guests. Our guest today is the managing partner of SPA Ajibade and Co. He was called to the Nigerian Bar in December 1989 and was elevated to the rank of Senior Advocate of Nigeria in December 2007. He's the first member of the Nigerian Law School set of 1989 to be so elevated. He obtained an LLB degree from the University of Ife, now Obafemi Awolowo University, in 1988. He obtained an LLM degree in corporate and commercial law from King's College, University of London in October 1990. He also has a PhD degree in private international law from the same university in October 1996. He's a fellow of the Institute of Advanced Legal Studies in London, an international practice fellow of the International Bar Association, and a fellow of the Chartered Institute of Arbitrators in the United Kingdom. He combines the role of an advocate, a corporate commercial solicitor, an administrator, a reformer, and has excelled in each of these areas. As a distinguished advocate, some of his milestones include the following. He made law in the Supreme Court. He led the team in the Supreme Court decision in Fashaking Foods Limited against Soshaya in 2006, and was able to convince the Supreme Court that the provision of Section 22, subsection 3 of the Federal High Court Act was unconstitutional. He also represented a client in the groundbreaking litigation before the ECOWAS Community Court of Justice, in which the Republic of Ghana was found liable to the client in damages to the tune of $800,000 for breaching the client's fundamental human rights. He also represented a leading Nigerian conglomerate in arbitral proceedings in the London Court of International Arbitration, in which arbitral award in excess of $50 million was compromised and settled based on evidence that the sole arbitrator had misconducted himself in the course of proceedings. Similarly, as an accomplished solicitor, he led the team that acted as solicitors to Consolidated Breweries PLC in its merger with Nigerian Breweries PLC. He also led the team that represented SRM Partners Limited in its acquisition of Fresh Shares Limited, a wholly owned subsidiary of FBN Holdings PLC. He also represented Broad Communications in its divestment of its shareholding in Airtel Nigeria PLC. He represented the Nigerian Insurance Brokerage Company in its acquisition by and merger with a multinational insurance company. He also led the team that represented First Bank of Nigeria PLC in its suspended 500 billion debt insurance program. As a business administrator and businessman, he also has extensive experience in corporate commercial practice and company secretarial practice, and has been involved in Nigerian capital market as solicitor in several public offers of security as well as mergers and acquisition. He's a founding member of the Capital Markets Solicitors Association, the CMSA, which was founded by Chief Anthony Digbe SCN in 2001. And Dr. Ajibade was his pioneer secretary between 2001 and 2007. He's vice chairman in 2007 to between 2007 to 2011, and chairman 2011 to 2013. He was also a member of the Rules and Regulations Subcommittee of SEC's Capital Market Committee from 2002 to 2004, and is vice chairman from 2004 to 2010. In recognition of his good judgment and business service skills, he was appointed to the boards of reputable companies, some of which are V-Mobile Nigeria Limited, now Airtel PLC, EcoBank Transnational Incorporated Lumia in Togo, FarmMake Nigeria PLC, a wholly owned subsidiary of Danone France, and the International Chamber of Commerce Nigeria. As a family man, he's happily married with 4 children. Please please join me in welcoming Dr. Ajibade, Babatunde Ajibade, SAN, fellow Chartered Institute of Arbitrators. Welcome once again, sir.
Thank you very much, Ayo.
All right, sir. So I'll just go straight into the Q&A session. We've received quite some questions which we will be throwing to you. Well, we'll start off with the question, which I believe I speak the mind of most corporate counsels and corporate law practitioners here. And the first question we have is, if you are elected as the president of the Nigerian Bar Association, what would be your distinct plan for company secretaries, legal advisors, general counsel, and the body of general corporate counsels?
Thank you, Ayo. My distinct plan for corporate counsel for that group that you have described would be to integrate them more into the activities of the NBA. I know ever since the creation of the NBA section on business law, there's been a conscious effort using the SPL as a platform to get corporate counsel, general counsel to be more active. And I believe that they are more active in the SPL. But my vision really would be to integrate them as well as the SPL more into the mainstream of the NBA's activities.
Okay, now many thanks for that. Now, recently, I am aware that there was a controversy where a senior advocate of Nigeria advocated that all his fellow colleagues and other learners should come together and enthrone a senior advocate as the president of the Nigerian Bar Association. There's been some other agitation in some areas, especially in regards to some other junior lawyers, to feel that the office of the NBA president is not an exclusive preserve of the office of the SAM. So, what will be your take on this, and can we have your thoughts on this?
I've already made my position on this public. I think I was the very first to react to Chief Awumolo's unfortunate statement. I disagree with it completely. I don't think there's any basis for it, either in the NBA's constitution or even in the historical antecedents of the NBA. I don't think there's anybody who disputes that the most popular and most effective president the NBA has had in its history is the late Alawa Kabashon. Late Mr. Alawa Kabashon was not a senior advocate. And indeed, as Ferdinand Obi has since said, I wasn't even aware of this, but Ferdinand Obi, SAN, has since pointedly identified the fact that there have actually been more non-SAN NBA presidents than there have been SAN NBA presidents. So even historically, there's nothing to support the contention that the presidency of the NBA is reserved for SANs. I don't believe that is the case. And I think that the leadership of the NBA should be determined based on the character, the capacity, and the plans of the individual for the NBA, not on the title that he or she bears.
Interesting. Many thanks for that exposition. I'll just go into another question, which is which we received along the line. So a corporate counsel wants to know that they want to know if you will make it a priority to facilitate Nigerian citizens who are abroad, who are non-Nigerian qualified and qualified in a foreign jurisdiction, to qualify remotely, or at least make the process easier. I don't know if you're able to get that question. This was a question we received from Mr. Wale Olufunwa, a corporate law practitioner. So he wants to know if you make it a priority to facilitate Nigerian citizens who are abroad who are not qualified in Nigeria, but who are already qualified in a foreign jurisdiction, to qualify remotely, or at least make the process easier for them to be qualified in Nigeria, I believe. So I believe it also speaks for lawyers that have foreign qualification but who are not qualified in Nigeria. So he's asking if there will be some sort of process to make it easier for them to be able to practice in Nigeria.
I think, the question is not so much about citizenship. It's about the nature of your training. So, I mean, whether you're Nigerian or not, if, for example, you studied law in China, I don't think the fact that you're Nigerian, or if you studied law in a civil law jurisdiction, as you may know, the two broad families of legal thought are the civil law and the common law tradition. Now, if you were trained in a civil law background or jurisdiction, I think it would be a bit difficult to say because you're a Nigerian citizen, it should be made easy or easier for you to qualify in Nigeria. I think what we should do, and like I said, I wouldn't so much tie it to citizenship, I would tie it to the training that you've received, is that anybody who has qualified in a common law jurisdiction, because the common law really is, the basic principles of the common law are the same world over, we should make it easier for people who have such qualifications to qualify here. The hurdles they should be caused or made to jump should be only such hurdles as are necessary for them to understand the local idiosyncrasies of Nigerian law. But once they have experience within another common law jurisdiction, I agree entirely that we shouldn't make it unduly difficult for them to be recertified to practice in Nigeria.
Okay. Many thanks for that. And I think I subscribe to that thinking also, so that to ensure that we have some sort of standardization of the process. Also, we have another question here, and that's to say that so corporate counsel wants to know what your views are regarding the liberalization of the Nigerian legal sector. They have also asked if capacity building should be synonymous with liberalization. What are your thoughts on this, sir?
Well, liberalization, it's something that we have to confront in a much more methodical manner. Liberalization is taking place already. I had the privilege of being on a committee that was established by a former NBA president, Okewale SAN. I think that was 2012, thereabouts. Committee was chaired by Yemi Kande Johnson SAN. And it was on this issue of liberalization of Nigerian legal practice and whether we should open our doors to allow foreign international law firms to come and practice in Nigeria. And we came to the conclusion that it's inevitable that sooner or later we're going to be compelled to open our doors, if not as a result of treaty obligations, be it WTO, be it AFCTA, just as a result of pressure from multinationals and our need to attract foreign direct investment. If there's a perception that this investment will not come or comes in a reduced manner because the law firms that piggyback on these multinationals are not being allowed to come in with them. But we also realize that there is a need to protect our domestic market, and that it would be foolhardy for us to open our doors to international law firms coming in here to set up until we have strengthened our own local market and until we had significant capacity in terms of skill, because that is what is lacking. I mean, a lot of these international law firms, going back to Mr. Olufunwa's question, for example, a lot of these international law firms have loads of Nigerians working within them anyway. So it's not that the skill is not there, but we don't have the skill to compete effectively with them domestically. And we think that we should increase our skill and improve on our regulation before we open our doors. So it has to be a calibrated thing. And we should study what other jurisdictions have done. There are a lot of examples to copy from. Malaysia, Singapore, a lot of the Asian tigers, where they've opened their doors in a structured manner. It hasn't been just a free-for-all. They've allowed international law firms in, but restricted them to specific areas of practice, all designed to protect the local industry. So restricting them from practicing domestic law and say they can only practice international law, etc. These are all things that I think that we must consider and deal with in due course.
Thank you very much for that, and quite enlightening and quite an eye opener. Frankly, personal note. My next question flows from this general feeling in the corporate counsel space that the MBA is significantly tilted and focused on litigation practice. Specifically, we received a question from Mr. Timothy Ajibade, who felt that the profession is rigged against corporate attorneys in terms of privileges and relevance. Because according to him, most of the regular content to which litigation lawyers go to court to argue on are prepared by corporate counsels. Hence, the corporate counsels keep the litigation lawyers in business, in quote. Now, the question from corporate counsels, which I believe I speak their mind, is that if you are elected MBA president, under your watch, what will you do to address this perceived disparity between advocates and solicitors, and therefore change this narrative?
I think that there's a lot that needs to be done in that space, but I think it's a lot that needs to be done on both sides. I think we need to be pragmatic. I'm concerned that we don't have sufficient statistics in our profession, and that is one of the things that I would like to deal with if by God's grace, I'm elected MBA president, because a lot of what we deal with is based on speculation. I think it's difficult to plan effectively for any group of people, any association, if you don't have the statistics. But even without the statistics, I have no doubt in my mind that the majority of Nigerian lawyers are litigators. I won't be surprised if it's in the region of 75 to 80% of Nigerian lawyers are litigators. So to that extent, I don't think that it is unreasonable or is a matter of surprise that this group of lawyers have dominated the affairs of the association. But I think it is unreasonable for them to dominate the affairs of the association to the exclusion of other groups of lawyers. And goes back to what we said about the SBL. It goes back to what I said about SPIDL, about SLP. This sections and various fora, if properly utilized, should enable every lawyer, irrespective of the nature of your practice, to find a place within the MBA where his or her interests are adequately dealt with. And to a large extent, if I had my way, there should be some form of proportional representation. So assuming, just for the sake of argument, like I said, that 75% of the profession is made up of litigators and 25% is made up of corporate practitioners, or 25%, 25%. I think that each of those sectors should have a proportional degree of representation in the MBA and in the MBA's management. So I mean, there's a provision, and I've made I've given an open undertaking to the Law Officers Association of Nigeria, for example, who have complained about the provision of Section 8.3, I think it is, of the MBA Constitution, which says that only private practitioners can aspire to hold national office within the MBA. And I agree with them entirely that that is unreasonable. There's no reason why corporate counsel should not be able to aspire to hold national office in the MBA. It's not just about law officers. So these are some of the discriminations that have been established over time that I think we need to do away with. But we need to do away with it, keeping in mind that the tail is not likely to be able to wag the dog. If the majority are in a particular area of practice, naturally, they will have an influence on the organization and on decision making going forward. But it must be within the context of allowing everybody to have a say. And my slogan on which I base my aspiration to lead the association is that we must have a united bar. there's no way we can have a united bar if we don't give everybody a sense of belonging and give everybody, including corporate counsel, the belief that their voices will be heard and that their concerns will be addressed.
Thank you very much. Quite insightful. As a follow-up to what you actually mentioned, which is about the Section 8 about the need to be legal practitioners to aspire to national offices, I'm going to also follow up by saying that a lot of corporate counsels also feel aggrieved, and it seems as though efforts from this space is not being recognized. And for instance, now I've had a lot of arguments and a lot of agitation that corporate counsels are excluded in the award of the rank of senior advocates of Nigeria. They've made a case to say that there are people in the corporate counsel space who have done significantly and added a lot of value to the legal profession that ought to be recognized. But as we speak currently, only legal practitioners who are in full-time practice and in some instances, academics are given the opportunity of becoming senior advocates of Nigeria. What are your thoughts on this, sir?
Well, my thoughts are that, again, those are aberrations that have been born out of the fact that the profession has historically been controlled by a particular group of those that practice it. And unfortunately, by dint of that, some of these habits or conventions have been reduced into statute. So, for example, the eligibility for appointment as a senior advocate is not really down to the MBA now. It's not an MBA thing. It is written into the Legal Practitioners Act, and so that it's a statutory provision. I personally have no reason. I see no reason why, if some argue that because it says Senior Advocate of Nigeria, that if you must appoint solicitors or corporate practitioners, you would need to change the name. But then my counter argument to that is, then how come you give academics? Academics are not advocates either. So if you give Professor A or Professor B, who have never, some of them have never stepped into a court, how do you justify giving them Senior Advocate of Nigeria and then exclude solicitors? So I think it's just a lack of will. I definitely am not of that school of thought. I've spoken to some distinguished solicitors who I know and who I personally feel are more than deserving of being appointed to whatever, whether you call it senior advocate or you decide to call it senior solicitor of Nigeria. I think that they're deserving of the same degree of recognition. The only question mark that I've raised, and I've raised this with them, is what would be the criteria? Because the truth is, even the rank of Senior Advocate of Nigeria, for those of you who know the late Pa Gomez, who just passed on last year, I mean, he went to his grave agitating for the abolition of the rank of Senior Advocate of Nigeria, because he felt that it was, even amongst advocates, he felt that it was unduly discriminatory, and he felt that the process and procedure by which senior advocates are appointed lacked transparency and was not based on merit. So my only concern with the agitation for solicitors to be either appointed senior advocates, or even if we were to create another rank, is that we need to be careful that we articulate, or that we're clear as to what criteria we want to use, so that we're not replicating the problem that already exists even with senior advocacy, in that a lot of people are not happy. It's not just about the fact of that other people other than advocates can't be made senior advocates, is that people are not happy with even the process by which senior advocates are appointed. They think it's too arbitrary and not merit-based. Now, I think we would have the same challenge if we created a separate category for solicitors, or if we decided to make solicitors senior advocates. The question would be, what criteria you should use? It's something that I've asked senior solicitors to start thinking about, because we're going to change that. My desire is that the Legal Practitioners Act is long overdue for review and amendment. So this will be the time, really, in the course of amending that legislation, to introduce these issues. And if we're going to introduce them, we might as well come forward with what we consider to be the appropriate criteria that should be taken into consideration.
Beautiful, sir. I think I'm excited when I hear that, and so at least I'm sure I speak the mind of other corporate counsels to say that it's actually exciting to know that is going to be reviewed, because we have a lot of corporate counsel who have actually contributed to this practice, especially in the corporate counsel space and in terms of corporate law practice. So thank you very much, sir, for that. My next question then, which is close to that also. So at a recent interview, you mentioned that if elected, you would work to fight all aspects of external intrusion into the lawyer's work. In fact, recently there was a recent publication by a tier 1 bank wherein SMEs and other businesses were invited to subscribe for legal services. In a lot of quarters, this was considered a serious encroachment on the job of the average Nigerian lawyer. What is your take on this?
Well, I'm sure you know that tier 1 bank very well.
Yes, I think I do.
Again, this is something that I've reacted to, the NBA has reacted to. I think one at least of the other aspirants to the presidency of the NBA has also reacted to this. I agree entirely, but I think we need to put it in context. And it goes back to what I said about my mantra, which I'm running for this office, the need to build a united bar. I actually think that what happened recently is a success story in terms of exemplifying what we can achieve when we stand united. Because when I saw the advert, I mean, it went viral. A lot of lawyers were up in arms about it. I sent it to the NBA president, and he said that, yes, definitely it was something the NBA was going to deal with. I also sent it to the chairman of the section on legal practice, and he also confirmed that there was going to be a formal protest written. Indeed, I was just informed yesterday that the Lagos branch, I haven't seen the processes, but I understand the Lagos branch of the NBA has actually commenced an action against the financial institution. But what I took away from it, which was extremely positive, was that I also spoke with the senior legal officers, corporate counsel in that financial institution, and also with the chairman of the ABCLA, I think it's called, the Association of Banks Legal Advisors, ABLAC, Bank Legal Advisors and Company Secretaries. Yes. And they confirmed to me that they themselves were aghast at the publication when they saw it, that it had nothing to do with the corporate counsel in the bank, and that it was a publication that was generated by their marketing department, working in conjunction with some external law firms. And at the moment they saw it, they insisted that it be pulled immediately, which I thought was great, because the worst thing would have been, which was my initial concern. My initial concern was that this was corporate counsel within a bank trying to provide legal services to the bank's customers, circumventing or excluding their colleagues in private practice. But it turned out that was not the case. And I was happy that, corporate counsel within the bank were at one with us, who are external counsel, that it was most inappropriate for the bank to have put out such an advert. That is the kind of collaboration that I think I would like to see between corporate counsel and the NBA and private practitioners going forward.
Okay, beautiful. Thank you so much about that. Then our next question then is this. We want to know if the NBA, under your presidency, if elected, has any plans to undertake some sort of advocacy to ensure that our laws are updated to ensure efficiency and to support the exigencies of corporate practice. For instance, the corporate counsels have lamented at different times about the obsolete nature of extant laws governing corporate law practice. For instance, the Companies and Allied Matters Act still remains obsolete, and in the recent attempt to update it was stopped at some point, leaving corporate counsels with an obsolete CAMA that is not fit for current practices, current corporate law practices. So what are your intentions to ensure that CAMA is amended finally if it gets passed? Are there plans for the NBA to be playing some sort of advocacy role in this regard if they're elected president?
Yes, definitely there are. I know for a fact that the NBA and the SBL have already and are already taking steps in this regard. There's a NASBA, there's a group called NASBA, the Nigerian business, sorry, I can't remember what the acronym stands for exactly, but I know that it's a collaboration between the NBA, SBL, and the National Assembly to assist the National Assembly in identifying all the laws, not just CAMA, but a lot of the laws that exist in our statute books that are outdated and that are requiring significant updating, amendment, or reenactment. And that is an initiative that must continue. I think that the NBA must also engage actively with the Law Reform Commission, because there is a standing body called the Law Reform Commission that is supposed to review our laws on an ongoing basis. And I know that the National Assembly actually has, or recently it was drawn to my attention, I shouldn't say I know, that the National Assembly actually has an office within the National Assembly complex reserved for the NBA to assist them with ongoing reviews of laws. So these are all institutions or organs that I would activate if elected president. I think that is something that we must do on an ongoing basis.
Oh, thank you very much, sir. And I'm sure that will be well appreciated, because I'm sure you're aware about the crisis, a mini crisis corporate counsels faced during the COVID pandemic, where annual general meetings were not held, were not able to hold under normal circumstances. And so it was felt that if the CAMA was significantly updated, it will be able to cater for such instances as that. So my next question then is this. I followed the recent interview you granted, where you mentioned that if you were elected the president of the NBA, you would work with relevant agencies to ensure improved remuneration and treatment for lawyers undergoing the mandatory NYSC program. You also said you work with relevant institutions to enlarge the employment space for lawyers to reduce the pressure on law firms and keep lawyers gainfully employed. How do you intend to achieve this?
I think by constructive engagement. You know, the first thing that I think is important that we must do as a profession, and I'm already working on that, and I would work on it and I'll continue to work on it irrespective of whether I succeed in my aspiration or not, is that young lawyers coming into the profession are not being provided with sufficient guidance as to the variety of options that are out there. I think, you know, the pressure that is on law firms is enormous, and law firms as currently structured, the market as currently structured, cannot accommodate or absorb all these lawyers. And I think that there's so many important roles for lawyers to play in society that, you know, I actually don't believe that we have too many lawyers, even though we're producing almost 7,000 every year. I think that there are roles for them to play. It's just that those roles are not being properly articulated, and those roles are not being properly funded. So I'll give you an example. There's a police duty solicitor scheme that's being run by some branches of the NBA. The most popular one is the one that was being run out of the Ikorodu branch, and a few other branches have been running them. Now, these schemes are run on a pro bono basis. So the lawyers that participate in them do it of their own volition and almost as corporate social responsibility. I don't see any reason why this should not be standardized and institutionalized. Personally, I think that every police station in Nigeria ought to have a duty solicitor paid for. If government will not pay for it, then we will raise the necessary funding for it, either from multilateral development institutions or from corporates. I mean, I'm sure if I came to some of my colleagues on this call and we articulated the benefits that we seek to gain from doing this, we'll be able to raise funding for it. And by so doing, raise jobs. I don't know how many police stations there are in this country, but definitely I think there'll be a lot of jobs to be created there. I think that every local government office in this country, we have 774, ought to have at least one legal officer.
Yes.
Then there are the corporates. There's civil society. There are a lot of civil society organizations. I just spoke about the National Assembly. I think the quality of the legislation that is coming out of our National Assembly, out of the state houses of assembly, out of even the local governments, because they also pass, bylaws, etc. I think there are a lot of roles for lawyers to play that we are not tapping into, and we're allowing the young lawyers coming out of law school to feel that the only path available in the profession is to get a job in a law firm. I don't think that that is the case. And also, my interaction with some of these young lawyers, what you find is that a lot of them are square pegs in round holes, because all these various roles that I say lawyers can play, different lawyers have different natural tendencies. They have a natural flair. So somebody who has a natural flair towards constitutional human rights issues, asking that person to apply to a commercial law firm where they're doing mergers and acquisitions and capital markets work, he or she is not going to find fulfillment or satisfaction in that job, because that is not what is his or her natural inclination. So I think as a profession, we need to be playing a more significant role in assisting young lawyers as they come in to the profession, to identify what their strengths are and to assist them to find fulfillment in the profession that will enable them to exhibit what their natural strengths are.
Thank you very much on that. In fact, it's a great idea that I've just heard. Thinking about putting legal officers in the police stations, which will, for me, it will improve the level of understanding of the law, even from the police station up there, especially when you situate it against the fact that we have youth corporate lawyers who are always returned or rejected by potential employers and who are always looking for where to serve. If we have an abundance of legal officers that can be employed, I'm sure that it's a great idea for them to be able to be employed at the police stations. So I actually applaud that initiative if it eventually comes to pass. Again, recently, sir, you indicated that one of the things we are to expect under your presidency, if you're elected, was the increased appointment of young lawyers into positions of responsibility within and outside the NBA. Our question then becomes this: will this also apply to corporate counsel and its in-house legal practitioners? For instance, I'm aware that most when the Nigerian Bar Association conference is being organized, the organizing committee is majorly made up of legal counsel from full practice firms. Is there any plan to incorporate corporate counsel into these appointments and into these kind of initiatives?
Most definitely. And as I said, I mean, this, in recent times, it's interesting what is happening in the NBA, and I'm quite delighted by the direction of travel by and large, because I mean and I keep going back to talk about the SBL, but truly I'm a founding member of the SBL. I was on its council for 4 years. I chaired the conference planning committee for its 2016 conference. And, the SBL has been a very good vehicle for trying to raise standards within the NBA and make the NBA a much more cosmopolitan organization. And I think that we've achieved that. What I think we need to be careful of, which as a core member of the SBL I'd always advocated, is that we should ensure that we don't create silos. And I'm seeing it happening, because this question you're asking, I think that more than ever before, in the last, maybe 4 years, the quality of the NBA's flagship event, which is its annual conference, has improved significantly because of input from the SBL. I mean, the SBL's annual conferences have always been, close to international standard. And it was always my hope that we would be able to infuse some of that SBL spirit into the NBA. And it has happened. It is happening. I mean, the last NBA conference, I think, was as close to international as well as SBL standard as one could expect. And I think that is largely because the corporate counsel, as well as corporate law firms, because it's not just about whether you are in-house, whether you're in private practice or not. It depends on the nature of your practice. The truth is, a lot of our practitioners, the majority of our practitioners are solo practitioners. And because of the nature of their practice, the level of exposure is also relatively limited. But I think the more we get corporate counsel and the more we get corporate law firms involved in the activities of the NBA, and not just on the sidelines, but in an active manner, then it will improve the standards of the NBA's operations right across board. And I'm seeing that happen already, and I'm glad that that is the case.
Thank you very much. That's actually quite insightful. So we have a question here there are considerations that actually, while you spoke earlier, you spoke about the Association of Banks, Legal Advisors and Company Secretaries. Similarly, I'm aware that there is also the Association of Company Secretaries and Legal Advisors of the manufacturing industry, for which I am a member. I'm also aware that is the NECA's Committee of Company Secretaries and Legal Advisors, which I belong to also. A significant number of such groups exist. The question then becomes, and some of these counsels, some of these lawyers do not belong to the SBL. The question then is, if you are elected NBA president, will the NBA be reaching out to these groups such that we can then have inclusion in the affairs of the NBA by these groups?
I would like to reverse that slightly.
Okay.
I think that those groups should reach out to the NBA.
Okay.
To ensure that the NBA is aware of their existence, because you've reeled out a long list. Those are the ones you know. In all probability, there's some that even you don't know. That's because true. There's so many subsets within our profession, and it is very easy for us to criticize and say that the NBA is not carrying its members along, and that all the NBA does is collect practicing fees from them and branch dues. But then, if they don't stand up to be counted, if they don't make their presence felt, if they don't make their presence known, I'm not sure that we can continue to blame the NBA for their lack of participation. They themselves need to engage. And I'll tell you, one of the things that I am hoping to do, if by God's grace I'm elected, which will require that everybody gets involved, and I think I've mentioned it already, is we need to know who we are. How many lawyers do we have in Nigeria? What is the nature of their practice? What is the nature of their job? If you're in private practice, where do you practice? Is it a law firm? Are you a solo practitioner? How many partners in your firm? What is the type of law you do? How much do you pay your staff? Because you get a lot of complaints about welfare. I don't see how we can deal with these issues about the welfare of the legal professional when we don't even know what the current state of play is. So I think it is important that we have that information. And one of the questions that I would like to put in the questionnaire, which I'm already working on, is, which associations are you a member of? So if you're a member of the Company Secretaries of Manufacturing Industries, please let us know. If you're a member of the Capital Market Solicitors Association, let us know. If it is the Real Estate Lawyers Association, there's so many of them. I mean, I was on a program the other day, there's a ELAN, Employment and Labor Lawyers Association of Nigeria. I didn't know anything about them until I was invited to participate. So there are probably as many of these associations as there are lawyers out there. Yeah, but the NBA is the umbrella body that covers everybody, and everybody must get involved in the affairs of the NBA and make their voices heard.
Thank you so much, sir. I think I support what you've just said. And just to read out a comment from Mrs. Ayatollah Jagan in support of what you have just said. She feels that corporate counsel, who are all on this call, should find out what is out there in the NBA and get involved. And we should stop hiding in our silos and ensure we get engaged in the affairs of the NBA, because there are different fora and sections that are actively recruiting lawyers from all sectors. This is just to support what you have just said about the need for these associations to reach out to the NBA. Thank you very much, sir, for that. We have another question here, sir, and that is to find out what your plan for a proper regulation of legal education is in Nigeria. The author says he understands that this is the responsibility vested in the Council of Legal Education, but he believes that the NBA has a critical role to play for proper regulation of legal education. He feels that the quality of our outputs leaves so much to be desired. And he also believes that there are too many lawyers scrambling to service a $400 billion economy. What are your thoughts on this, sir?
I agree entirely. I agree that the NBA has a role to play. I mean, the Council of Legal Education has NBA representatives on it, and I think that over the years, it wouldn't be incorrect to say that the NBA representatives on the council have perhaps not done enough to assist in improving the quality, the content of the curriculum. But the truth is, there are changes now. There are changes that are taking place in the world, and in our profession is not excluded. That will, by force of circumstance, cause all of us to start thinking differently about what our lawyers need to be taught. And it's not even just for those who are in training, even for those of us who are already in practice. The challenges that we're now all being confronted with increased use of technology is going to necessitate a lot of retooling and retraining right across board. So I think the NBA must play a role in that. Must play a role in making our profession a lot more responsive to the changes that are taking place. And as I think it's Mr. Nwodo says, we also need to start thinking about opening up new practice areas. I mean, he says that we're too many, that we're producing too many lawyers for a $400 billion economy. The truth is, as I said earlier, that may well be so if we assume that lawyers only play an economic role. But I think lawyers play a much broader role in society. There's so many roles that lawyers play that are not necessarily of immediate or at least not direct economic relevance, but are of relevance to the maintenance of a civilized society, that are relevant to the protection of the rights of citizens. So, and when we look at it from that perspective, I actually don't think we have too many lawyers. I think we have too many lawyers trying to do the same thing. But if we opened lawyers up to the various other roles that they're expected to play in society, and if we made those roles as important, if we recognize them the same way we recognize commercial success, then I think we would encourage a lot more lawyers to head in that direction, and would realize that we don't actually have too many.
No, thank you so much for that. Mr. Uche Matthew has asked the question that senior corporate counsel and the seniors of the senior corporate counsels hardly encourage or allow their juniors to attend or participate in MBA activities. How do you intend to integrate that? How do you intend to get them if you're elected to the presidency of the NBA, to get them to participate actively in the affairs of the NBA?
I mean, that is a wonderful question, and it goes back to the point I made earlier when we were talking about the various groupings, and you were saying that what was the NBA going to do to reach out to them? And the point really is that, you know, I think all lawyers ought to reach out to the NBA. And I've heard this, you know, there are even lawyers who are interested in participating in NBA activities, but whose employers, you know, would say to them that what's your business with NBA? You know, you've been employed to deliver a particular service. You know, MBA is not is not part of it's not on the horizon.
Yeah.
We need to change that mindset, and those who have interest should be permitted to participate.
Yes.
I think it's a two-way street, really. There has to be cross-fertilization of ideas, and lawyers must show more interest. And as I say to those who I am seeking support from, I say we must also hold our leaders to account. Talk is cheap, but if I or any of the other aspirants to various MBA offices make a whole load of promises, and then you vote any of us into office and you don't hold us to account to deliver on those promises, then we wouldn't have done ourselves any favors.
Okay, beautiful, sir. My next question, I have another question here. So an anonymous question here. We have, so he has said, thank you, Lennon Silk. He wants to know what your views are on the ban placed on in-house counsel from representing their employers in court proceedings. He feels that there are many in-house counsel who have the experience to represent their employers in court, but are prevented from doing so, But he feels that given the present legal regime as per the rules of professional conduct, is there anything you can do if elected to address this issue?
I think that is the probably the biggest elephant in the room, or whether it's gorilla, whatever animal we want to choose. You know, as between in-house counsel and private practitioners. And on another forum last week, I was quite frank in saying that, look, this is something that I think we must have a frank discussion about. No matter how sympathetic I might be to the concerns of corporate counsel who feel that the restrictions contained in the rules of professional conduct are too extensive. The fact is, if we don't have such restrictions, then we might as well eliminate, we would naturally be eliminating a significant proportion of the source of livelihood of legal practitioners. Because if large corporate organizations like Berger Paints, like the banks, could engage lawyers in-house to represent them in court and do everything that external counsel do, then really what would external counsel have to do? Because, you know, they'll probably just increase the number of lawyers they have in-house, put them on a fixed salary and say, well, you know, we were sued, you go. We have this major M&A transaction to engage in. You deal with it. It would basically make private practice non-viable. So I think we must. I mean, my honest view is that some of those restrictions have to remain. Now, do they all have to remain? I don't think so. So I think there's a discussion that we have to have around the provisions of, I think it's section, I don't know what section it is of the rules of professional conduct, but I think the blanket restrictions are probably too broad, because it also raises the flip side of that question is, what is the point of an in-house counsel being engaged if the rules of professional conduct effectively say that he or she cannot perform any legal function, you know, for the employer? So we have to strike a balance, and that is one of the areas where I think it is important that corporate counsel are engaging actively with the NBA, because the rules of professional conduct definitely are long overdue for review as well. I don't think we should eliminate those restrictions completely, but I think we need to renegotiate them.
Okay, sir. Beautiful question. And to support what you have just said, we have Mrs. Ayatollah Jagun, who also feels that if that is done, if the restrictions are taken off, it will represent it will create some sort of conflict of interest situation.
And lack of independence.
Exactly, sir.
Yeah.
So we have the next question we have, sir, is that there's a bill before the National Assembly to amend the Companies and Allied Matters Act. One of the proposed amendments is the deletion of Section 35(4) of CAMA, which gives lawyers the exclusive privilege to sign statutory declaration of compliance when incorporating a company. Most junior lawyers are earning a living on the basis of this provision. His question is there a step or measure you can take to prevent this deletion from happening?
I would definitely argue against that deletion occurring. I already know that a lot of lawyers, not just young lawyers, a lot of lawyers are up in arms about the fact that their work at the Corporate Affairs Commission, the role they play in the incorporation of business entities, is being eroded. But the challenge, the greater challenge for me, though, and I've made this clear to lawyers who raise this, is that the greater challenge I think that we will confront in this area is not so much the amendments to the laws, but the encroachment of technology, and the fact that we also, as members of society and who also have a stake and an interest in the growth of our economy, must be aware that there is a pressure, significant pressure to improve on the ease of doing business in Nigeria, because we're competing for investment. And that one of the criteria for ease of doing business world over is the ease and the cost attached to establishing business entities. So I think that pressure, which is leading the CAC to try, has been trying for a while, is still struggling with it, but it's getting there slowly to automate its processes, is sooner or later going to eliminate this as a source of work for lawyers, as a significant source of work anyway. Because sooner or later, business people are going to be able to incorporate businesses online without using any third-party interface, be it lawyer or non-lawyer. But for as long as that hasn't occurred yet, I think we should do the best we can to protect that source of livelihood for lawyers.
Beautiful, sir. Thank you very much for that position. And we also have a question from Mr. Nonso Aze, who is the head of legal for APMT Apapa Limited. His question is: there is this unwholesome presumption that in-house lawyers are not practicing lawyers, and he's asking what can we do to change this negative connotation, given that law practice goes beyond law firm activities. He feels that a lot of corporate counsel have had extensive law firm practice and continue to add positively to building a philosophy of law in line with best international standards. So he's asking what can be done to change this narrative that in-house lawyers are not practicing lawyers, especially in view of the fact that they've contributed to building the philosophy of law.
I think that is it's what would be the appropriate word to describe this now? I'm not, perception comes to mind, but I'm not sure it's even perception. It's not a perception issue. I think it's a misconception issue. I know a lot of lawyers who are in-house who were in private practice. I know a lot of lawyers who were in, and vice versa. Law is such a versatile profession. I know lawyers who have been in-house who have gone into academia. I know lawyers who have been in academia who have come into practice. We are able to do a variety of things. So I agree entirely with Mr. Azi that for anybody to say that, oh, because you are in-house, you're not practicing or you're not a practicing lawyer is a misconception. But then there are different types of practice. indeed, one of the things that, as I was saying earlier about providing guidance for young lawyers coming out of law school, one of the things I would like to do is to engage with distinguished practitioners in-house, in academia, in the human rights environment, in government, etc., and get them to tell these young lawyers their stories. Because these stories are not, there's no one size fits all. There are lawyers who have gone through the entire gamut. There are some who, either because they were so focused, had gone straight into just one aspect of practice. And they come with different, the benefits, the pros and cons. Is it better to first practice in a firm before going in-house? Is it better to go in-house first and then go out? Is it better to go in, out, as some people have done? There's no one size fits all. So to say to any particular lawyer that, oh, you're not in practice because you are in-house, or that it's only if you wear the wig and gown that you're a lawyer, I don't share that school of thought. And the truth is, again, as I'm speaking to in-house counsel, I know a lot of in-house counsel who their knowledge of the law trumps that of those in practice. So it really is, like I said, I think it's a misconception. I don't share that misconception.
Thank you very much for that. And we also have a question from Mrs. Ayotola Jagun, who wants to know. She says that there's been a gradual erosion of the rule of law in our polity, and this is of great concern. She says she's asking that what will you do as president of the NBA if elected in strengthening the rule of law, the independence of the judiciary, and the constant overreach of executive powers by MDAs and organs of government?
I think again, that is one of the greatest challenges facing us now in the society, because the rule of law presupposes obedience to court orders. That is the entire foundation on which civilized society is based, that might is not right, and that there is an impartial and independent arbiter, which is the judiciary, and that irrespective of who is on the other side, whether it's government, whether it's another individual, whether it's a big man, a small man, that independent arbiter will deliver a fair decision, and that decision will be obeyed. Now, we're in a situation in Nigeria where we see time and again that precept, that basic precept of law, is being turned on its head, and there are too many instances now in which court orders are not being obeyed. There's a variety of reasons for this. People complain about the lack of independence of the judiciary. We complain about the fact that the judiciary is dependent on the executive for its funding, and a variety of things. But my honest belief is that this challenge is truly a challenge of the mindset and the quality of our judiciary. Independence is not a vague concept. Independence is a mindset. If we had, back in the day, even when we had military regimes, when we had people walking around with jackboots, we had a judiciary that would stand up against government and say that, we would declare this decree unconstitutional, and we would not entertain matters involving the government until our orders are obeyed. But today, the majority of our judicial officers don't seem to have that independence of mind, and I think that is the real challenge. Because when people say to the NBA that what are you going to do about disobedience to court orders, I mean, what first occurs to me is that the judge who made the order, what has he or she done about the disobedience to his or her order? Because the dignity of the judiciary it should be sacrosanct. Looking to the NBA or looking to individual lawyers to ensure enforcement of the orders of a court, I think is the judiciary shirking its responsibility. Definitely, the lawyers have a role to play in activating the necessary processes. where an order has been disobeyed, perhaps initiating contempt proceedings, seeking ingenious a variety of ways of compelling obedience. But at the end of the day, the judiciary itself must show a lot more angst and concern about the fact that its orders are being disobeyed. I'm not seeing that. I'm not seeing that. So it's a problem, and I think that there's no magic wand that anybody is going to wave to solve that problem. For me, it's a long-term, at least medium-term solution, is to improve the quality of personnel that are going into the judiciary. We need to ensure that the people have the right mindset, that they have the right training, they have the right skills, and that they're not, because some of them have lost their independence even before they get on the bench, because they get on the bench as political appointees. They become judges because they know somebody in government. So the independence is lost even before the game started. So these are things that we need to nip in the bud, and I think the NBA has a significant role to play there.
Thank you so much. The next question we have is from Ms. Cecilia Amadwekwe, Company Secretary, Legal Advisor for Julius Berger Nigeria PLC. She says that we are working.
Can I make a disclosure? That's a question from my sister.
For your sister. Okay, that's nice to know. So she feels that we are working in perilous times, and sometimes the fights become personal and a crusade. She's asking if you are ready for this, and how do you intend to ensure that the legal structures in Nigeria are well protected?
I told you she's my sister now, so she's concerned for my safety and well-being. Well, it goes back to the question I was asked a few days ago, recently, as things have started to heat up, that oh, you're too soft, you're too much of a gentleman. Are you sure you can confront the rigor or the challenges of this office you're seeking? And I say that the taste of the pudding is in the eating. Yes, it's not necessarily by making noise or being seen to be loud and perceived to be aggressive. I think the challenges confronting us, what they require is character, character and conviction. If you have character and you have conviction, I don't think anything will shake you. And I believe that I have both of that in large quantities. The worst thing that can happen, and which to a degree, and I mean, I'm not pointing fingers at anybody, but I think that our profession, when people think back to the days of Alawa Kabashon, it's because it wasn't because he was loud or noisy, it was because he was resolute. He was resolute, and he could not be bought, he could not be swayed. I believe I'm cut out of that same cloth. So I have no doubts that I will be able to withstand the challenges that will come with this office.
As a follow-up to that also, maybe this is my question to you. Since joining the NBA presidential election race, what has been your expectation? What is your expectation vis-a-vis the reality? Was this what you expected it was going to be, or what has been your experience so far?
My experience has been actually extremely rewarding, and it's been rewarding. It's been fulfilling. I've been to parts of this country that I would never have had cause to go to. I've met people that give me, a great amount of faith. Of course, some have been major disappointments, but I've met people that given me a great amount of faith in the potential for this country if we would only allow the right people to get into the right positions. And I believe, quite honestly, that there's a yearning. People want a change. People are yearning. People in our profession, people in society at large, are yearning for a different type of leadership, be it at professional level like the NBA or at every other level. And that if they perceive sincerity, they're actually, keen to give that person an opportunity to prove his or her. So that is what I found, and I find it quite encouraging. So I have absolutely, whether I win or lose, I have absolutely no regrets for stepping forward, because for me it's been an eye opener.
Beautiful, sir. I just have one or two questions because I know we are significantly out of time. My question is this: being a boardroom guru yourself, there's been since the arguments from some quarters, especially in corporate counsel space, that company secretaries should actually be considered for being directors. I know that in some companies, actually, they have that structure because of the critical role the company secretary plays. Being a member of the board also, I want to have your thoughts on this argument from some quarters to feel that the company secretary, by virtue of his role, he sits across different sets of board members. So in a lot of instances, is probably the most experienced in terms of in terms of institutional knowledge and how the boardroom has worked. And so some people have made the case that company secretaries should not just stop at being company secretaries; they should be considered in some circumstances to be directors. What are your thoughts on this, sir?
I think that makes perfect sense. I mean, the role of the company secretary as the guardian of the corporate governance of any corporate entity definitely places him or her in a very good position to step up from being company secretary to being a board member. But I would stop short of making it appear as though we are arguing for an automatic promotion. That once you're company secretary, then automatically you graduate from there to a board position. But I definitely don't see any reason why a company secretary who exhibits the right skills on the job should not be given consideration for board appointments when they come clear. And indeed, this is one of the areas where I think the NBA has to work together with corporate counsel as a group, because one of the complaints I've heard is that even within corporates, and this complaint I heard particularly with the banks, I don't know, it might apply to other corporates as well, but that if a cohort of graduate trainees, for example, join a corporate institution, and some are lawyers and they go into the legal department, and others go into mainstream aspects of what that corporation does, the chances are that the lawyers will hit a glass ceiling a lot quicker, and that their progress through the organization is halted, whilst those from other disciplines tend to, the sky is the limit for them. I mean, that is something that I think that as a profession, we must tackle. There shouldn't be any reason why, being a lawyer in a corporate organization should restrict you or limit your ability to rise through the organization, which ties in with your question. If you're a company secretary, why shouldn't you be eligible for a board appointment or even for the CEO position?
Beautiful, sir. That's quite beautiful position, sir, and I actually align with that, especially because to some extent I can say that a lot of corporate counsel have said this. I think this comes from the perception that where corporate counsels are engaged in say a financial institution, for instance, they are seen as back-end staff, and so for the finance guys, they go up, but lawyers are considered like they have a limit to which they can go. So it will be quite interesting to see what the NBA can do under a war chief elected. We have a comment here by the Managing Director of DCSL, Mrs. BC Adeyemi, who also feels and subscribes to your opinion that company secretaries should be able to aspire to the board, same way as other senior management get appointed as executive directors.
Yeah.
So my final question, sir, will be for the indecisive lawyer, what should, for the indecisive lawyer, what would you say to them to make them decide to vote for Dr. Babatunde Ajibade as the president of the NBA?
I think two things. The first, and for me the most important, is my integrity. I think that the perception of our profession over the years has suffered a significant battering because too many of us have been perceived as behaving in less than stellar manner. And I think we need to do everything we can to remedy that and to redeem the image of the profession. And I think electing leadership that doesn't have blemish or question marks is a step in the right direction where that is concerned. But secondly, and perhaps less subjective, because whether I have blemish or not, I suppose that's my view.
Yeah.
Others obviously could form their own view. So, yeah. but I think more objective is the fact that of the contenders for the office of president of the NBA, I don't think anybody can dispute the fact that I'm the one that has the broadest base in terms of experience. I'm a litigator and a senior advocate of Nigeria by virtue of that. I'm an experienced corporate practitioner. I have a significant number of transactions under my belt. I used to chair the Capital Markets Solicitors Association, like you said. On top of that, I also sit as an arbitrator, which is the next closest thing to being a judge, because I have a clear understanding of the rigors that judicial officers go through in having to listen to a variety of arguments and try and arrive at what is the justice of the matter. So I think this variety of experiences cannot but stand me in good stead relative to the other contestants in addressing the concerns of the various aspects of our profession that require attention. So that would be my reason for saying I'm the best choice.
Beautiful, sir. That's quite impressive. I don't know if I can quickly take one more question, which you have just, God. So we have a question from Mr. Nonsu, head of legal for APMT. He feels that, sir, are you going to be able to do something if elected NBA president about lawyers grooming? He feels that over time, a lot of lawyers have looked rather unkempt and lack social decorum. He feels that there is a need to reposition the brand because the level of respect we get as lawyers is a direct correlation to our composure, knowledge, service, mannerism, and decorum. Is there any plans? What do you have? Are you plan to do anything else, sir?
Yes, I mean, I think this is just the flip side of what I said about, or what I just said about the redeeming the image of the profession, and this actually touches on what in my manifesto I've identified as the flagship, what I consider to be the immediate and most urgent priority, which is addressing the welfare of the legal professional. And the welfare of the legal professional, there's a wide gamut. So there's the welfare of the legal professional, right from magic circle firms even in our own environment, who might feel threatened by competition from international law firms. So we need to protect their welfare, even though some would say that they're already doing very well, but we need to make sure that they do even better. When I talk about building scale, I think we also want 1,000 lawyer, 400 partner law firms in Nigeria. And we need to protect that market to enable them to develop that scale. But then at the other end of the spectrum is the fact that there are too many lawyers in Nigeria today who are struggling even to put a meal on the table for their families. You know, I say that if we don't address the welfare of the legal professional at all ends of the spectrum, we will get the kind of issue that Mr. Azi has raised, because the conditions under which a lot of lawyers are operating, it really is not a condition that any lawyer should be proud of. And every time you see a lawyer in that state, you know, unkempt, looking hungry, disheveled, it reflects on all of us, no matter how well we are doing. Yes. Because society thinks if that's a lawyer, if that's the way lawyers are, then they can't really be saying much. So I agree with him entirely that we need to address this, but I think the way to address this is to address the welfare of the legal professional in a holistic manner, not just those at the top end, but also those at the
Thank you so much, sir. I know we've taken a lot of your time, and I know in the build-up to the elections, you'll be having a lot of interviews, a lot of meetings, and so I want to thank you for finding time to speak to us. I believe that a lot of my colleagues also have gained significantly from this Parley. So I want to thank you, and I want to appreciate you and also everybody that has found time to join this meeting. Finally, I'll just call on the organizers, Kaizen Academy, who has organized this, to give a word of thanks to everybody that has joined this meeting. Ms. Obiageli Madueke, please. Ms. Obiageli Madueke, are you there? Okay, I think I need to give okay. Okay, so while I think she's struggling to come in, so I'll do the vote of thanks on our behalf. So, dear Lindsay, thank you so much. I know the effort it took for you to actually find time out of your schedule to meet with us, and also speak to corporate counsels and address some of the issues which has bothered us, and we wish you all success. We wish you every success in the election. I also want to use this opportunity also to appreciate corporate counsels and company secretaries, heads of legals who have found time to join this meeting. Ms. Obiageli, if you are here in a minute, I'll just say a word or two. Okay, so I think you're still having that problem. So thank you so much, Lensil. We appreciate you.
Thank you very much.
And we wish you the best as you go closer to the election. And just like Mrs. Cecilia Madupe has said, we hope the rigors won't be too much for you to deal with as we care about your welfare. Thank you so much again.
Thank you so much. Thank you, everybody. I appreciate it.
Thank you very much.
Thanks.
Thank you, sir.
Bye.